Hello everyone, I am Shivani and welcome to Vakilaw, Know the Law. So in today's session, we are discussing about the subject of drafting, pleading and conveyancing. I have discussed in my previous sessions regarding the drafting part and have also begun with the concept of the pleading part and a few more points. So what I discussed in my previous session was an introduction to the meaning and concept of pleadings. Later I discussed about the fundamental rules, which were the general rules of pleading. I also discussed about the objects of pleading and also about the functions of pleading. I am sharing links of my previous sessions regarding to drafting and the first part of pleading in the description box below. Do check them out. So now in today's session, we will be discussing about the fundamental rules of pleading, which are the substantive rules of pleadings. So let's get started. The first substantive rule of pleading is that pleadings should state facts, not law. So it's a pleader's duty to set out the facts to be relied upon and not the law or legal inferences. It is not enough to allege that the defendant was guilty of misconduct. In fact, the pleader should state the facts regarding the conduct to be observed by the defendant, misconduct which is pleaded, basis of such misconduct in the plaintiff's opinion, and breach of conduct should be alleged. The court shall then examine and infer from them that the defendant is guilty of misconduct. The plaintiff should only state the facts leading to the cause of action against the defendant and not required to plead the law under which he claims a decree, and also it is not essential for the defendant to mention points of law in his written statement. So I have discussed about it even in my previous session. I am repeating the same, that the plaintiff or anything which forms a part of the pleadings should only state the facts of the case and no any law or legal inference should be mentioned in the plaintiff or written statement as the case may be. So pleadings of facts are necessary. It is also necessary that the pleadings should be specific and not vague. So there should be no any ambiguity or any vagueness in the plaintiff or written statement that is to be presented. It should be specific and to the point. Also, the plaintiff must contain the facts, otherwise it will be considered to be bad. So the next substantive rule is pleadings should state material facts only. So pleadings should contain only material facts on which the plaintiff and defendant rely for their respective cases. All essential facts shall be alleged by the parties for the claim and defense and not the irrelevant ones. The words material facts means the facts that are necessary and relevant, and the concerned party must prove those facts at the trial unless of course admitted by the opposite party. So according to Order 6, Rule 2 of the Code of Civil Procedure of 1908, material facts are required to be stated. Also, as provided in Order 6, Rule 4 of the Code of Civil Procedure of 1908, particulars wherever necessary are required to be given. So the next substantive rule is pleadings should not state evidence. This can also be stated as facta probanda and not facta probentia. It means that pleadings are to be made only facta probanda, that is material facts, and not facta probentia, that is particulars or evidence. So the plaintiff is not required to come out with the evidence in pleadings, which he will adduce at the trial to prove the facts and allegations. So Order 6, Rule 2 of the Code of Civil Procedure of 1908 states that every pleading shall contain only a statement in concise form of the material facts on which the party pleading relies for his claim or defense, as the case may be, but not the evidence by which they are to be proved. So the next substantive rule is the facts in pleadings should be stated in concise and precise form. So the pleadings should not only be concise but must also be precise. Although the pleadings are required to be in brief, they ought to be made with accuracy and certainty. The pleadings must be certain and definite. They must be clear and should not be sacrificed for the sake of brevity. So for example, a general charge of corruption cannot be allowed in a pleading. The corruption must be specific and alleged specifically in the pleading. Thus, the exact nature of corruption should be mentioned so that opposite party must reply and submit his defense in relation to that particular allegation of corruption. Lack of precision in pleadings destroys the main object and the very purpose of pleadings. The use of pronouns should be avoided and instead plaintiff or defendant, as the case may be, should be used. Otherwise, use of pronoun he will create ambiguity. So wherever it is required, it should be written particularly as where it is the plaintiff, the word plaintiff should be used, and wherever defendant is required, the specific word of defendant should be used. No any ambiguous terms like he, him, she, her should be used. That may create vagueness, ambiguity, and also will create confusion before the court of law. So the material facts should be stated in the pleading in a concise form, but with precision and certainty. The pleading shall, when necessary, be numbered consecutively. Dates, numbers, and sums shall be expressed in figures as well as in words. So whenever you have to write, for example, you have to write an amount of rupees 1000. So you have to write 1000, and also you have to write rupees 1000 only. So it is figuratively as well as in words. You have to write it in numbers also, you have to write it in words also. So the parties can take alternative pleas, meaning that the plaintiff or defendant are entitled to rely upon two or more different sets of facts. But the only factor is that such alternative or inconsistent pleas should be based on facts which are not contradictory or inconsistent. So this is the most important point, that though the plaintiff or defendant can rely upon two different sets of facts, they should not contradict or should be opposite to the concept or set of facts which have actually been pleaded or which have actually taken place. So they should not contradict to those facts or not even contradict to the facts that have been provided by the respective parties. So this is what is the substantive rule for pleadings. So to conclude for the entire concept of pleading, so we've spoke about the meaning, or even we've spoke about the object or functions or the general as well as substantive rules of pleadings. What is that we can conclude? So the first thing that we understood from all of the things that I discussed is only material facts should be alleged. The second thing is statement of material facts should be in brief. So it should be written in a concise, precise and in a brief form, and you should not write very long sentences or anything that will create ambiguity or vagueness, or which is not necessary to be known, or which is not that important to be mentioned, can be excluded from the plain or written statement. So evidence by which the allegations are to be sustained should not find place in the pleading. And also pleadings should not only be concise but also should be precise. So that's all for today. I hope that the information that I have provided to you is useful, and I also hope that you like my videos. If you like them, please hit the like button, share my videos, and yes, don't forget to subscribe to my channel, Vakilaw, Know the Law. Till then, this is me Shivani signing off. Bye-bye.